What you are watching is a total breakdown of courtroom order, something almost never seen in a federal trial. There were no warnings, no delays, no final chances. Acting on direct orders from the bench, United States Marshals stepped into the courtroom, seized documents, controlled the exits, and effectively froze a high-stakes trial in real time. The defense didn't just test the limits, they went straight through them. After the Witness 14 recordings leaked, the presiding judge issued a decisive ruling that sent shockwaves through the legal community. People were removed immediately. The courtroom was locked down. Marshals positioned themselves between attorneys and the exits. This wasn't a procedural dispute. This was open conflict inside the justice system, and it had just reached a breaking point. So what triggered such an extreme response? 47 minutes before marshals moved in, a damaging leak surfaced online. Audio from protected witness interviews, recordings that were never meant to be public, began circulating. According to court filings, those recordings point to coordinated witness tampering tied directly to the defense side. This wasn't a routine argument over legal strategy. The court treated it as an organized assault on the integrity of the trial itself. And when you examine the timeline, the transcripts, and what unfolded inside that room, the reaction becomes impossible to ignore. To understand why, you need to understand the judge. A 23-year veteran of the federal bench, he has overseen organized crime cases, terrorism prosecutions, and complex RICO trials involving cartel leadership. He is known for being unshakable, calm, controlled. Court watchers have described him as the most composed person in the room until today. Multiple sources say that when he reviewed the leaked audio, his demeanor changed. One court reporter noted his jaw tightening, his hands gripping the bench. Moments later, he issued the order that stopped everything. Secure this courtroom now. So what was on those recordings that shook a judge with more than 2 decades of experience? Here's what the Witness 14 tapes reportedly contain. Witness 14, whose identity remains sealed under federal protection, was a central insider expected to testify about high-level financial fraud inside the defendant's organization. According to filings that surfaced during the chaos, the witness had direct knowledge of falsified documents, hidden accounts, and coordinated efforts to obstruct federal investigators. The leaked audio allegedly captures 3 separate phone calls between Witness 14 and individuals prosecutors say are connected to the defense team. In the first call, recorded 11 days before trial, a male voice is heard telling the witness, "You don't have to remember everything. Confusion helps everyone." On its own, that statement raises alarms. The second call, recorded 8 days later, escalates sharply. The same voice allegedly warns, "If you mention the March transfers, this becomes a different conversation for everyone, including your family." Legal analysts reviewing the transcript have described that language as classic witness intimidation, barely disguising the threat. But the third call is what prosecutors say crossed the line completely. 72 hours before the trial began, a different voice female allegedly delivered what investigators are calling the kill shot. The witness is told that a testimony package has already been prepared, that they are to study a summary document, and that they must not deviate from the approved responses. Any improvisation, the voice warns, could put the witness protection agreement at risk. That is the core allegation: scripted testimony, pressure to comply, and an explicit warning tied to personal safety. According to sources close to the investigation, audio forensics linked voice patterns from these calls to phones registered to 2 associate attorneys working under lead defense counsel. When that evidence was presented during an emergency chambers meeting earlier today, the judge's response was immediate and unambiguous. This court will not be made complicit in the manufacturing of perjury, and the recordings may only be the beginning. Investigators say the leaked material includes operational discussions about payments, future considerations, and what happens when witnesses go off script. A former federal prosecutor reviewing the evidence described it as the most explicit case of defense-side witness tampering he had seen in over 3 decades. This isn't a gray area. This is black-letter criminal conduct captured on audio. The evidence package reportedly includes 14 separate audio files totaling more than 6 hours, text message logs showing coordination between unidentified numbers and defense team members, financial records suggesting payments routed through a shell company to the witnesses' relatives, and internal memos outlining testimony management strategies. But one detail has stunned seasoned court observers. Sources say the leak did not come from prosecutors. It came from inside the defense team. An internal fracture. Someone deciding to burn everything down. A former Justice Department official summed it up bluntly. When a leak comes from within the defense, it isn't an accident. It's someone deciding that professional loyalty matters less than avoiding prison. That suggests the rot may run deeper than even these tapes reveal. And this is why today exploded the way it did. This case, already described as the most significant white-collar prosecution of the decade, began 17 months ago with indictments against corporate executives accused of orchestrating a multi-billion-dollar fraud scheme. What happened today may have just changed everything. The allegations behind this case are staggering. Prosecutors say pension funds were devastated, retirement savings for thousands of workers were wiped out, and regulators were allegedly bribed to look the other way. From the very first day, the courtroom atmosphere was combustible. The defense team, led by veteran trial attorney Harrison Mercer, adopted what critics described as scorched earth tactics. Every piece of evidence was challenged. Motion after motion was filed. Prosecutors were repeatedly accused of political motives. The strategy was clear: slow everything down and muddy the waters. The prosecution, led by Assistant U.S. Attorney Patricia Delgado, took the opposite approach. They argued the evidence trail was extensive, documented, and difficult to dispute. 3 months into the trial, the first serious warning signs appeared. Judge Caldwell issued a rare formal admonition after defense attorneys were observed communicating with a family member of a sequestered juror at a public restaurant. The defense claimed coincidence. The judge called it troubling proximity to obstruction. 6 weeks later, another moment rattled the courtroom. A prosecution witness suddenly changed testimony during cross-examination, directly contradicting sworn deposition statements. Observers described the witness as confused and disoriented, struggling as if trying to follow a script that hadn't been fully memorized. The prosecution requested a mistrial. Judge Caldwell denied it, but from that point forward, court watchers noticed his attention locking onto the defense table. Then came witness 14. This witness was expected to explain the mechanics of the fraud, identify key decision makers, and connect executives to offshore accounts through a clear paper trail. One analyst called it the ball game witness. The night before that testimony, the recordings appeared online. They were uploaded to an encrypted file-sharing site and spread rapidly through legal journalism circles. By early morning, major outlets had the audio. Shortly after, prosecutors filed an emergency motion. Minutes later, Judge Caldwell called an unscheduled chambers meeting. Not long after that, United States Marshals began moving into position. When the judge returned to the courtroom, witnesses say his expression reflected what one reporter described as controlled fury. He did not sit. He stood, stared directly at the defense table, and made it clear that aggressive advocacy had crossed into criminal territory. And then the courtroom shifted from legal crisis to physical control. Those inside say it unfolded in under 90 seconds, but felt far longer. As the judge finished speaking, the defense team froze. Before any objection could be raised, marshals stepped forward in unison. 2 moved to the defense table. 1 blocked the main exit. Another positioned beside the court reporter. The gallery reacted with shock and confusion. Some journalists initially believed there had been a security threat. Faces went pale. Chairs scraped backward. A marshal instructed counsel to remain in place, not approach the bench, not remove documents, and not communicate with anyone outside the courtroom. When an objection was attempted, the judge cut it off instantly. The transcripts show 11 full seconds of absolute silence. That was the moment everyone understood this was not theater. This was not a warning. This was the end of that trial day and possibly the end of multiple legal careers. But the real damage begins after a courtroom is sealed. Courtroom chaos is not unheard of in American history. In the Chicago 7 trial, dramatic judicial actions shocked the nation and sparked debates over overreach. In later cases involving fraudulent attorneys, judges moved quickly once evidence surfaced. But those cases involved individuals. What is being alleged here is far larger. Legal scholars say the closest comparison may be the Watergate prosecutions, when lawyers tied to a presidential campaign were charged with obstruction. But even that comparison falls short. In this case, the allegation is that officers of the court themselves used the justice system as a weapon. And unlike past cases, technology changes everything. Witness tampering was once hard to prove, relying on circumstantial evidence. Here, investigators claim there are time-stamped recordings, voice matches, text logs, and financial trails. In the digital age, the line between suspicion and proof has narrowed. Several former prosecutors have said they have never seen a federal judge physically contain a defense team during active proceedings. The language used by Judge Caldwell, specifically his emphasis on preserving the integrity of evidence, suggests he believed additional criminal evidence could exist right there at the defense table. In that moment, the courtroom itself became a controlled evidence scene. Some legal experts say the move was unprecedented but defensible. When officers of the court are suspected of becoming participants in tampering, the court is not only allowed to act, it is obligated to act. Others warn that what happens next will matter just as much. Appeals, disbarments, criminal referrals, and potential indictments may follow. This case is no longer just about corporate fraud. It is about whether the justice system can protect itself from those sworn to operate within it. This story is still unfolding. If you want to stay informed as new developments emerge, make sure to like this video, subscribe to the channel, and share your opinion in the comments below. Your perspective matters, and this case is far from over.